I'd like to welcome everyone to the panel on reproductive rights and the search for compromise and consensus. My name is Pam Harris. We are fortunate to have a wonderful panel today. I'm going to introduce everybody very quickly and really quickly, and I apologize in advance because I won't do any of them anything like justice. Right to my left is Anita Allen Castellito, who is a professor of law at the University of Pennsylvania Law School, the Henry Silverman Professor of Law, Professor of Philosophy, also a senior fellow of the university's bioethics department in the School of Medicine. She's written extensively on the subject of reproductive rights. Next to her is Allison G., who is the Vice President of Public Policy for Planned Parenthood of the St. Louis region. She has a long career in health policy and pro-choice political and legislative work, and in Missouri has played a key role in the passage of Missouri state legislation on prenatal substance abuse and maternal and child health care reform. Next to Allison is Nancy Northup, who's the president of the Center for Reproductive Rights, a global human rights organization that uses constitutional and international law to secure women's reproductive freedom, and works with women's rights advocates around the world in over 45 countries. Next to Nancy, we have Professor Teresa Stanton-Collette, who is a professor of law at the University of St. Thomas School of Law in Minnesota. In addition to academic scholarship on this subject, Professor Collette is very active in the legislative and litigation arenas as well. She's spoken at meetings of the National Right to Life Committee, testified before both houses of Congress in support of parental involvement laws related to minors' abortions, and tell me if I'm getting this wrong, but I believe represented the Illinois State Medical Society and other physicians groups supporting Nebraska's partial birth abortion ban in the original Carhartt case before the United States Supreme Court. All right, with those totally inadequate introductions, I'll say just a word or two about format. We're going to start with some short opening remarks from our panelists and then move on to a discussion among the panelists and leave a lot of room at the end for questions from you. So please, if questions occur to you as we're talking, remember them, write them down, something like that, and we'll leave time at the end to take questions. Nia, would you like to start?
Thank you. So the plan is that we're going to each talk for maybe 5 minutes or less even. Okay, so here's my opening remark. I guess while I was a law professor, although I'm a law professor, I've also been pretty active in the pro-choice movement. I was chair of the board of Planned Parenthood of Metropolitan Washington back in the mid-90s, and I have been involved with the Family Planning Council of Philadelphia as a member of their board and their IRB, and I've also been involved with a organization in Philadelphia called the Women's Medical Fund that provides microloans for poor women who would like to have abortions. So I spend most of my time in the ivory tower, but I also have been on the ground thinking a lot about and helping women to achieve their reproductive rights. As a privacy scholar, I have closely followed abortion law since the 1980s, when the attack on Roe versus Wade went into high gear. And I'm really puzzled by the call for compromise. I think all Americans want safe sex and also want to have fewer unplanned pregnancies. So there's an awful lot of consensus. As for compromise, I thought Roe versus Wade was a compromise. In the 1970s, many women and their advocates wanted a secure national right to safe medical abortion. The reasons were that poverty and rape and economic inequality, domestic violence, birth control failure, all these conditions resulted in unplanned and unwanted pregnancies. On top of that, it's for some women a matter of life and death. It can be dangerous to be pregnant and expensive. So for some people, carrying a child to term is the least responsible, least ethical and moral thing to do, and that's one position. On the other hand, many religious groups, individuals, and right-to-life advocates opposed abortion back in the 70s, and they said it was wrong to kill fetuses, and that women who got pregnant should stay that way for their own sake, moral sake, and sake of the fetus. Unwanted children, they said, could be placed for adoption, or if a home could not be found, at least life was better than no life. Life without a parent is better than no life at all. So, in my view, by allowing women who want abortions to get them, but forcing no one to have an abortion or to perform an abortion, Roe was a compromise, and a very, very important and historic one. There were, of course, after Roe, more compromises from the Supreme Court. Here's just a couple. First of all, there's the compromise not requiring government agencies that fund prenatal care to also fund abortions. No abortion funding. That's a compromise. Allowing states to put up notice and consent roadblocks to teen abortion. That's a compromise. Allowing states to require waiting periods. That's a compromise. Allowing government to gag state-employed physicians who might wish to discuss abortion with their patients. That's a compromise. And to go on, like allowing states to put in preambles to their laws of statements endorsing the pro-life position. That's a compromise. So despite the fact that Roe was a moderate compromise, the fact that the Supreme Court has upheld additional compromises makes the call for compromises to me seem a little bit inappropriate and puzzling. The Supreme Court recently upheld the oddly named Partial Birth Abortion Ban Act in the Gonzalez versus Carhartt case. And this law makes it a crime for a doctor to do something that she has to call a lawyer to find out if ever even she wants to do it. I think that Sarbanes-Oxley and the Patriot Act are better laws when it comes to drafting than the Partial Birth Abortion Act was. This law makes it a crime to knowingly kill a fetus, viable or not, by a process of dismemberment once the head or umbilicus, in the case of a breech first presentation, travels below the woman's cervix. How arcane is that? Turns out that very, very few of the millions of abortions take place every year are partial birth abortion of this general type. The law does not affect most women directly. But for some women seeking abortions, this might well be the safest course. The Supreme Court says, too bad for you. The law doesn't need to make an exception for women's health. Okay. So I hear the cry for compromise as simply efforts to chip away at the right to choose abortion. I really don't think there's much to the call for compromise. So we've already had lots and lots of compromises, and we're getting even more compromises. One ground for opposition to abortion rights, especially popular today, is, I think, pernicious, and I want to say diabolically pernicious, and it's apparent in the Gonzalez case. This is the opposition to abortion premised on the need to protect women's delicate mental health. Women regret their abortions. They find them depressing. They get suicidal. Their lives are ruined by misleading and deceptive abortion business people. Women are too poor, too uneducated, too beset by hormones and confusion and male domination to think for themselves, they say. Women need to be discouraged from abortion. They need to be counseled, shown videos, counseled again, educated with graphic, gory surgical images and cute, cuddly ultrasounds, and prayed over. They say that too. Justice Ginsburg's dissent in the Gonzalez case was, I think, brilliant, unsurprisingly. And I think it cut through all the tired and twisted 19th century notions about what women are really like. Even if most of us she hasn't forgotten the ties between the ability to have private abortion rights and women's overall equality. The latest calls for abortion compromise are way too paternalistic. Women make and they live with life and death decisions, transforming their lives and lives of others every single day. There's nothing unique about abortion in that respect. Women make these hard choices all the time. There's rarely a state senator or representative or congressperson on hand to tell us what to do when we are faced with ethical and health decisions in our everyday lives. I brought my 11-year-old daughter with me, and I think she's outside, but I had this fantasy that I was going to have her give the sort of the call and response answer to the next 4 rhetorical questions I'm going to ask, and then I'm going to shut up. Okay. So here's my questions. All right. But I thought it would be really, a little bit much to have your 11-year-old daughter get involved in this discussion. But anyway, so question. When a woman is diagnosed with emphysema, who decides when and if and how she stops smoking? She does, chimes in the 11-year-old. If she gets cancer, who decides whether it's chemotherapy, radiation, lumpectomy, or mastectomy? She does. If a woman's elderly dad is senile and having trouble caring for himself, who decides whether he goes into a nursing home or lives with her in her home? She does. Who decides when it's time to pull the plug on Nana? She does. When a woman needs to decide whether to buy a house or keep her money in her bank account, who decides? She does. If a woman has an opportunity to divorce or marry, who gets to decide? She does. If a woman's child may die without experimental surgery, available only in France, who decides whether to get on the plane? She does. If a woman thinks she might want to run for president, who decides? She does. My point here is that this current tendency to try to fight the abortion fight by infantilizing women and treating women as if they are too fragile or unable to make up their own minds and need a lot of guidance and counseling and information is a mistake. And it's a mistake that's been made for centuries. We've got to stop making that same mistake. So compromise, we've already done that, and the current movement towards paternalism, I think, is a great mistake.
Great. Okay, so I'm not an attorney, and pretty soon you'll figure out I'm not originally from Missouri. But that's where I live now. And actually, I went to Missouri in 1989, ironically, as regards this particular panel, with the founder of Reproductive Health Services, which is the abortion clinic in the Webster versus RHS case that many of you have heard about, right after the Webster decision in '89, to look at putting on the ballot a constitutional amendment to the Missouri Constitution that would have protected the right to abortion and contraception, but would have left in place the laws that were then on the books in Missouri. Compromise. Hated universally by both the pro-choice movement and by the anti-abortion folks. Hated. In the end, we didn't put it on the ballot, mainly because the ballot language was thrown out by a judge weeks before the deadline for signatures. But it was ironic that that was really an attempt at looking at, can we just, basically freeze ourselves in place here and then move on with our lives and move on with other issues of importance to women and to Missouri. I then started at Planned Parenthood about 10 years later, the same year, interestingly, that a comprehensive sex ed bill was passed, a really good one that said if school districts wanted to voluntarily teach sex ed, it had to be age-appropriate, medically and factually accurate. It had to teach about both the benefits and failure rates of contraception, and parents could opt out. They could opt their kids out of it. School districts got to choose the curricula, very local control kind of based. And that was a compromise that was negotiated between a Democratic senator who was rabidly, I'll say rabidly, anti-abortion, one of our biggest nemesises in Jefferson City, and various groups within the pro-choice movement. And it was moved to this place where it truly was, from our point of view, good public policy that assured comprehensive sex education. The downside at that particular time was there was no money put in for making sure that it was actually implemented. So we know school districts didn't follow the law. And when the abstinence-only funding came through the feds, we knew even fewer school districts were really complying with the law, but nobody was taking them to task on that. So that's just an interesting issue. It was the same year also that our Infants Protection Act was passed, which was our version of the so-called partial birth abortion bill, which interestingly wasn't resolved until just this year after the Gonzalez decisions. But I just want to go through, in the last few years, what it's looked like in Missouri. So really no legislation was enacted after Webster. Granted, the Infants Protection Act was passed, but it was enjoined until this year. But in the last 4 or 5 years, we've seen at least 7 measures passed that in one way or another restrict access to abortion or to information. We had a 24-hour mandatory delay bill passed with a 2-physician visit requirement. So now a woman must come for 2 visits, one pre-visit where the informed consent process occurs, and 24 hours later she can come back for the procedure. What this has in effect done, aside from making it hard to find enough physicians to do all of the counseling as well as the procedures, is that we're beginning to see women being pushed further into the pregnancy before they have their abortions. We know women have to now, if they've traveled more than 100 miles to get to us, which is 1 in 6 patients, they have to spend the night. So there are additional costs, and we know there are additional costs in terms of both money, but also, you know, who's going to take care of the kids at home while they're gone for 2 days? How do they get 2 days off of work? So we know already that there are problems coming from that. We then also had new requirements that physicians providing abortions at a clinic must have surgical privileges at a hospital within 30 miles of the facility. Now, this was a new requirement, not in fact prompted by anything that had happened, by any particular complications, by any women dying. But what it in effect did was in Springfield, Missouri, southwest Missouri, very Baptist, very Bible Belt area, in order to get privileges at a hospital, the hospital has to grant them to you. And it's not just, you know, goodness of their heart. It's, do you get something? Does the hospital get something by granting privileges to that physician? Well, hopefully you don't get anything from a provider of abortion services, because hopefully you don't send women to the hospital. So the 3 hospitals there wouldn't provide surgical privileges to any physicians that would work at that facility. The facility has since closed. Now, they would say it's not because of the law, but it's interesting that it would be very, very difficult to find a hospital that would give a physician privileges. We just this year had a piece of legislation passed, as we refer to it, TRAP legislation, Targeted Regulation of Abortion Providers. It requires that any provider of abortion services that provides 5 or more first trimester abortions a month be licensed as an ambulatory surgery center. Now, that's regardless of whether it's a surgical abortion or a medication abortion, where there is no invasive surgical procedure. What that will effectively do is close down the 2 other providers in the state that provide either medication abortions or early surgical abortions, and will leave 1 provider for the state of Missouri, and that's Reproductive Health Services in St. Louis. That goes into effect the end of August. At the same time, what we've seen over this period of time, the postpartum Medicaid waiver family planning services was reduced from 24 months to 12 months. The state, very successful state family planning program that provided women's wellness and family planning services to 30,000 low-income women who didn't qualify for Medicaid, didn't qualify for, or didn't have private insurance, was eliminated because they couldn't, after 10 years, find a way of keeping Planned Parenthood out. They also, this year, the governor discovered that the Planned Parenthood clinics in southwest Missouri had been providing breast and cervical cancer screenings through the CDC project and canceled those 18-year contracts. We have seen, we actually pursued attempts to get family planning funds through the legislature that wouldn't go to Planned Parenthood, but that would actually go to public health clinics, health department clinics. So no fear of fungibility, you know, somehow underwriting abortion services. That failed. We've seen also then this year a very good public policy around sex education decimated. School districts can now choose to teach comprehensive sex education, or they can choose to follow federal abstinence-only guidelines, which in my mind is sort of like saying, okay, with your math curriculum, you can teach 2 + 2 = 4, or 2 + 2 = 5. But I'll tell you what, if you teach 2 + 2 = 5, you'll get money. So from our point of view, it's encouraging federal abstinence-only guidelines. And in addition, they also banned not just Planned Parenthood sex educators from public schools, but anybody affiliated with, and any of their materials, with a provider of abortion services, which is defined very broadly to sweep in also referrals. So it's going to take out of the pool of experienced, trained educators, many nurses, doctors, and folks that work with organizations that believe in providing full information to women when they ask. So those things have been going on. In the meantime, when you look at our 10-year statistics, maternal child health statistics, 95 to 2005, our most recent period, infant mortality has stagnated at 7.5 per 1,000 live births. Of course, for black women, it's double that, and has actually increased, not just stagnated. Low birth weight percentages have increased, again, at double the rate for African American women. Preterm births are up. Short birth spacing is up, of less than 18 months. 18 months or more spacing between births provides better outcomes for mom and baby. And throughout that whole entire time, abortion has been decreasing. And yet we continue to focus in our legislature on finding ways to prevent women accessing abortion services. And in our state, in the last 4 sessions, 72 bills have been filed that in one way or other restrict access to services, including last year we had 4 abortion bans. We couldn't just do one, we had to have 4 abortion bans. But they chose not to pursue the abortion ban because they prefer, as I say, the frog in the pan method, which is, you've probably heard this, if you throw a frog in a pan of boiling water, it'll jump out. But if you put that same frog in a pan of water and turn the heat up slowly, it'll boil. And that's essentially, I think, what we're seeing in states like Missouri, where it's death by 1,000 cuts. At the meantime, we're trying to look at a proactive agenda that really emphasizes preventing unintended pregnancies, which we know from polling statewide and nationally is what the majority of Americans believe policymakers should be focused on, reducing unintended pregnancies through comprehensive sex education, access to family planning, rather than putting further restrictions on access to abortion services. So that's the state perspective.
Thank you. Well, I think that Anita and Allison have said everything there needs to be said about both the call for compromise and the harms that come from the execution of compromise. So I'm going to change the focus a little bit and see what can be said maybe about consensus. And I want us to take a wider look at this issue than in the United States and turn our attentions to what has been going on internationally. And I will make the very bold statement, which I'm sure will be met by Teresa with perhaps not an agreement about consensus, but I will argue that I think that adopting reproductive rights as human rights is where the consensus ought to be. Now, let me also just say, because I can't not say this, the title of the panel is about reproductive rights, and we're just talking about abortion today. And I just have to make the point, of course, which I'm sure everyone in this room knows, which is the reproductive rights are much broader than the right to abortion. It's about a bundle of rights concerning women's sexual and reproductive health, from the right to carry a safe pregnancy to term, to access to contraception, to access to sex education that we've just been talking about. Forced or coerced pregnancy is a reproductive rights issue, or its opposite, forced sterilization or forced use of contraception. Outside the U.S., child marriage, female genital mutilation. So I just had to say that so that we get hit all the time. And in the international human rights arena, often the use of reproductive rights by the U.S. government is said to be just about abortion, and it is certainly not. So there's a host of reasons to widen the lens to look internationally. In the 15 years since the Center for Reproductive Rights was founded, there have been 2 different trends going on in the law. In the United States, as you heard so well from Anita, the trend, the center started a couple months before Planned Parenthood versus Casey came down. So in the U.S., what we've seen in those 15 years is this general erosion of the protection of reproductive rights, and the latest salvo from the Supreme Court in the Gonzalez versus Carhartt case, in which this new introduction of state interests, the concern about women, the paternalism that Anita talked about. So we have this, erosion of the protection going on in the U.S. law, and then an opposite trend going on in sort of the international human rights arena, in which reproductive rights are increasingly being placed inside the understanding of human rights as is seen used in the international human rights treaties, in regional covenants and conventions, and by some national constitutions. So one reason to widen that lens and look outside of this conversation in the United States is because the discussion here is so stale and keeps going around and around and around, as was yesterday's panel on backlash. Was Roe a bad decision? Should it have been done legislatively instead? That around and around and around discussion needs to be opened up. Also, when you widen the lens and you look at it as a factual matter, it makes clear that abortion is a very common experience for women everywhere in the world. It is a common experience for women in the United States. It's the most common surgical procedure in the United States. 1 in 3 American women will have an abortion by the age of 45. And worldwide, there are 46 million abortions a year. Widening the lens also makes clear that criminalizing abortion, and again, the Supreme Court just upheld was a criminal ban on a safe abortion procedure. Criminalizing abortion doesn't radically alter abortion rates. It does alter the deaths and injuries to women, but not the abortion rates. About half of the abortions in the world each year take place in countries where abortion is illegal and for women without means unsafe. And you take a place, for example, like Chile, where there's a complete ban on abortion, and there are 6 abortions in Chile for every 10 live births. So when you look around the world, you see that the criminal approach to abortion does not affect women's access to it. Widening the lens also lets us see what these other legal frameworks can be. And it often surprises people to realize Canada has no criminal abortion law. There is no criminal regulation of abortion in Canada ever since its Supreme Court struck down Canada's requirement previously. In 1988, they struck it down, that you had to go to a doctor and you had to get the hospital's imprimatur to your decision to have an abortion. And so they've operated without it. And what is interesting when you look at Canada operating without a criminal abortion law is that you find that women there, like here, 90% have their abortions in the first trimester. And in Canada, only 2 or 3% of abortions are after 16 weeks. So again, you see that the legal framework around abortion doesn't alter when women have it. They have them early when they can. And in Canada, of course, there is a public health system that covers the costs of abortion. And so it is even more accessible for them. And I would also say the thing about widening the lens is that you realize that this issue in the Carhartt case, so-called partial birth abortion, was a complete political invention for the U.S. political stage. Nowhere else in the world are there any laws about partial birth abortion, because it is not a real issue. It is a political issue. And it's quite remarkable to think that we got all these states engaged for over a decade on this issue. We got the Supreme Court twice engaged on this issue, and it is a completely phony issue. And so widening the lens, which I want to talk about now, is also, you can see that where their trend is going is that reproductive rights are being protected as human rights. There was a groundbreaking decision in 2006, which I'm going to talk about, from the Constitutional Court in Colombia, in which they explicitly recognized reproductive rights as human rights and went through the rights to life and health and non-discrimination and equality and self-determination, all those things that underlie women's right to access abortion. And there have been other decisions before the UN Human Rights Committee. The Center recently settled a case with Mexico under the Inter-American Convention. The European Court had a court case this year in which they're recognizing that the right to access abortion is a human right. And this is a shift in the framework from this criminal framework, which governed for a long time. It's a shift it understands and incorporates the public health framework, but it's a social justice framework, and I, again, will argue that that's where the consensus should lie. But before we turn there, I just want to say a few things about some basic medical facts. I'm often when I talk to student audiences, I'm also often amazed at how few folks have ever maybe experienced pregnancy. And sometimes I remember speaking at the University of Chicago about 2 years ago, and there were maybe 100 students there. It was actually an ACS event. And I asked, who in this room has carried a pregnancy to term? And nobody raised their hand. One guy raised his hand and said, my wife did. Does that count? And similarly, when I was in my seminar that I teach up at Columbia Law School this year, we were talking about causes of maternal death worldwide. And one of those causes is obstructed delivery. And a student raised her hand and said, you know, well, what's obstructed labor? I thought, oh my gosh, she's 26 years old, and so I opened it up to the whole class. So what's obstructed labor? Nobody knew. I'm like, the baby gets stuck and the woman dies. So just a few things. We so jump into the law and politics discussion here in the United States that we kind of skip over some of the medical and biological facts. Without contraception, the average woman would have 12 to 15 pregnancies in her lifetime. That's the obvious answer about why access to contraception, and when contraception fails or isn't used to abortion, is the reality behind women's need to control their fertility. Otherwise, they can't begin to control their life. They can't have a sex life. They can't have a work life. It'd be hard to have a family life. It'd be a very big family life. Can't control their health, their finances, and maybe even their very life itself. 1,400 women die every day in a pregnancy-related death. That is like 4 planes going down every day in which women are dying related to pregnancy. And 700,000 die annually from unsafe abortion. In places like Kenya, which ban abortion, 40% of maternal deaths are from unsafe abortions. And maternal deaths, again, here in a developed country like the United States, where we have good obstetrics care generally. In North America, the rates for death in connection with pregnancy are 1 in 3,700. In sub-Saharan Africa, it's 1 in 16. So as Anita said, pregnancy can be a dangerous event in a woman's life. And that is only the tip of the iceberg. There are obviously also major health problems that can come in relation to pregnancy. And the other medical facts, which I won't go into now, but often get forgotten, are just those medical facts around the development of the fetus from what constitutes pregnancy, which is the implantation of the ovum in the uterine lining, the difference between a fertilized egg and a blastocyst and an embryo and a fetus and viability and all those things, which are medical stuff that need to be known when you're talking about this issue. And then also the medical facts around abortion procedures, which were heavily discussed in the most recent Supreme Court case, and Carhartt was built on those facts. So, having quickly touched on what pregnancy and abortion can mean as a factual matter for women's lives, let's look at the wider lens. 1994 was the UN International Conference on Population and Development in Cairo. So this was a UN conference at which they, for the first time ever, 179 governments, including the United States, signed off explicitly recognizing reproductive health as a human rights issue. Now, the reasons they did so are the ones that I just went through about how serious pregnancy can be to a woman's health and life. And from there, now they did not address specifically the abortion issue, but what's happened in the years since the Cairo conference is that framework of understanding reproductive health as a human rights issue has been built in application at both the national level and at the regional and international human rights level. And the Center and others have been getting authoritative interpretations of international and regional treaties to find a protection of the right to abortion under them. And what you've also seen developing is that groups like Human Rights Watch a few years ago took on abortion as a human rights issue that they will deal with, and Amnesty is going in the same direction. So I want to talk about the Colombia case from 2006. Colombia had previously, like many Latin American countries, like many Catholic countries, had banned abortion in virtually every circumstance. And a challenge was brought to Colombia's abortion ban, and astonishingly, the Colombian Constitutional Court said you've got to have exceptions to the ban on abortion for the life of the mother, for the physical and mental health of the woman, for fetal abnormalities, for rape, for incest. And what was stunning was not just the breadth of the exceptions which the court required, but the way they went about their analysis. They began by asking the question, the right to life obviously is often thought of as the right to fetal life, and they began by asking that question, is the right to fetal life protected in some of the treaties that Colombia has ascribed to? And they looked at the Treaty on the Rights to the Child, which does talk about the unborn, and they looked at the Inter-American Convention, which talks about the fact that the right to life is protected by law and in general from the moment of conception. And looking at those, they said, but that doesn't mean there is this recognition and this of the importance of the development of embryonic and fetal life, but they said it doesn't mean that that trumps the other important rights that are protected in those treaties and others of women. And so I think it's, again, as Anita said, it's the kind of compromise that was inherent in Roe, to look at the rights to the developing fetus and the rights of the woman, the same kind of analysis and balance that was done by the Canadian court when they looked at it. And they said there just is not an absolute unconditional obligation to protect fetal life. They then looked at the various human rights treaties, and they came to this conclusion. And I just want to read from it because it's really quite, it is quite notable, and I would say this is where we should look for all countries and the United States to be finding their consensus. The court wrote, it is evident that certain situations affect women in particular, notably those concerning their rights over their bodies, sexuality, and reproductive lives. Many international instruments provide a basis for recognizing and protecting women's reproductive rights, notably through the protection of fundamental rights such as the right to life, health, equality, non-discrimination, freedom, bodily integrity, and to be free from violence, all of which stand at the core of reproductive rights. When women's reproductive rights are violated, other rights are also affected. These include fundamental labor and education rights that can serve as parameters for protecting and guaranteeing sexual and reproductive rights. And then here is the line that the Colombian Constitutional Court says. Women's sexual and reproductive rights have been finally recognized as human rights, and as such, they have become part of constitutional law and, in turn, a basic foundation of any democratic state. They then go on to look at those different rights that they have unpacked there. And one of the first ones they look at is women's right to equal dignity. And they say decisions involving a woman's life plan, such as those concerning reproductive autonomy and moral integrity, are fully within the scope of the protection of women's human dignity. This takes the concrete form of a ban on imposing stigmatizing gender roles. It is completely the opposite approach to what the Supreme Court just took in the Carhartt 2 case, in which Justice Kennedy uses very traditional notions of women's role as mother and making judgments also, as Anita talked about, of women's abilities to make decisions. So the court looks at the issues of dignity and equality and says, to this extent, lawmakers pondering the adoption of criminal laws must not brush aside the fact that women are fully entitled to human dignity and are to be treated as such, not considered mere instruments for the reproduction of the species, or in some cases forced to serve as instruments of procreation. So the court then goes on to look at some of the other things that we talked about in terms of health and life and rights to privacy, and strikes down, requires that there be these exceptions, and then says, by the way, the government health care system has to cover the cost for an abortion, because that's what it would mean to treat those women with equal dignity to their health care. So the Colombian case, I would say, articulates in a perfect way the human rights principle that one of the concurring justices in Canada's case, Judge Wilson, had said almost now 20 years ago. She talked about how the history of human rights since the 18th century has been men struggling to assert their dignity and common humanity. And more recently, Judge Wilson said, it is women's struggle to, quote, achieve a place for women in a man's world. And that's the direction that we need to be continuing to go in. Thank you.
I think that's a perfect segue to my response, in that the fundamental question that faces the Supreme Court in American society now is, does the availability of abortion liberate women? And both my personal and professional experience says no. So let me begin with a personal story. When I was a second-year associate at the largest law firm in the state, I was pregnant. And it was, as Guttmacher Institute will tell you, an unplanned pregnancy. What I often refer to when I'm lecturing, it was an oops baby. It was our second child, but according to Guttmacher Institute, 50% of all pregnancies in this country are oops babies, are unintended. And Christy was an unintended child. Doesn't mean she was unwanted, but it does mean she wasn't planned. Your second year of associateship at a large firm is hardly when you would necessarily plan to have a child. I had made an appointment to tell my partner, who was supervising my work, later that afternoon. But prior to that, went to lunch with a girlfriend of mine who was also a second-year associate at the law firm, and who prior to going to law school had actually been a partner in what was then a Big 8 accounting firm. I know there's no such thing as Big 8 accounting firms anymore, but that shows how old I am. All right. And so when I told her at lunch that I was expecting our second child, her immediate reaction was, well, of course you'll have an abortion. I said, that's a very odd response. And she said, well, you'll never make partner if you have a baby during your associateship. I said, why do you believe that? And she said, well, everybody knows. That's the way the world works. I said, okay. And are you willing to accept that? And she said, well, you know, there's really not much that can be done about it. I said, well, let me tell you, I'm not willing to accept that. If I'm working for a law firm where the partners would actually require me to have an abortion in order to make partner, I don't want any part of it. That's not liberation. That's making women become men. And frankly, I'm not as good a man as some men I know. Better than some I know, but nonetheless. So I went and talked to my partner, and what's even more disturbing is, in fact, the first woman partner at our firm had had 2 maternity leaves prior to being made partner. The woman who is now president of my firm, or was at least last year, I haven't checked the status yet this year, had pregnancy during associateship. But it's that sort of presumption that the culture can demand that women not experience pregnancy and the role of mother, and that it's inconsistent with professional advancement, that the availability of abortion has bought us. So in looking at the topic for today, which was the search for compromise and consensus, I actually agree with Professor Allen that compromise is not the right word. But that doesn't mean that there's not common ground. The Pregnancy Discrimination Act that's been in effect for over 30 years is something that I think both those of us on the pro-life side and those on the pro-choice and even the pro-abortionist, and there is a difference, I think can rally around and agree. Women ought not forfeit their jobs because they've gotten pregnant. We're in Washington, D.C., and in 2001, there was actually a pretty prominent scandal because the Metropolitan Police Department in this city required young female employees to take a pregnancy test as a condition of employment. And after 4 female medics revealed that during their training they had been told that if they wanted to keep their jobs they had to get an abortion, the national media got involved. So abortion is a solution to what many men consider the woman's problem. It isolates women. It makes women solely responsible for the consequences of voluntary sexual conduct. And if you look at Guttmacher Institute's statistics on why women seek abortion, the number one reason is because of abandonment by their partner. It's not made women equal. It's provided us the opportunity to compete as men, but I think I would like a more fulsome vision of what women's rights means. I'm more interested in the idea that I can make partner even if I do have a baby or two along the way, that I can be a mom and a partner at a major law firm. I'm not interested in having a sterile, barren life beyond my professional life, which I think is what abortion and its availability has provided us. A couple of our speakers have talked about the fact that there are now one criminal law on the books related to abortion that's enforceable under Gonzalez versus Carhartt. I was active in that case, and I think that to the extent that Professor Allen recognized it as a compromise, I think it's a compromise based not on the availability of abortion, but on the necessity of that particular method of abortion. And I recognize we're after lunch, but I hope that we're significantly enough after lunch so that we can talk about the medical realities. In fact, there's one part of Justice Ginsburg's dissent that I agree with. When you have a late second trimester or third trimester abortion, there are technically 4 methods of abortion that are available, but the most common 2 methods of abortion are dismemberment abortion or what is known as partial birth abortion, DNX or DNE abortion. By far, the most common method of abortion is where the abortionist dilates the woman's cervix, inserts a sharp instrument, and begins to dissect that which is within the woman. Probably will first remove a leg, then a second leg, then an arm, the torso, and ultimately the head. This dismemberment process causes great emotional anxiety on those who engage in it. And so in looking for a method that would both relieve the need to reassemble the fetal parts, which is necessary to make sure that no fetal parts remain in the woman, because retained fetal parts is the #1 cause of infection according to the National Abortion Federation's textbook on abortion. They have to reassemble the fetus, which can be a rather grisly and unfortunate experience. Another abortion provider decided that there would be a method that would allow them to take the fetus out intact, which is partial birth abortion or DNX abortion. Now, at the time of the first Carhartt decision, what's interesting is that none of the expert witnesses used this procedure. The only doctor that testified in Carhartt 1 that had ever used DNX abortion was Dr. Carhartt. But notwithstanding that, and you can look at the trial transcripts, notwithstanding that, the United States Supreme Court said, well, it's possible that it would be safer. So because of that, notwithstanding that none of the experts had ever used it, we're going to say it's unconstitutional to ban it. In Ayotte versus Planned Parenthood of Northern New England, a somewhat unrelated case, but it has this relationship. The question in the New Hampshire parental involvement law was whether or not it had to have a threat to the mother's health exception. A brief filed in that case documented from public health departments the absence of abortions done for adolescents related to health. For example, the Texas parental involvement law has been on the books now for over 4 years. Not a single emergency exception due to the health of the mother has been performed in that state, notwithstanding that thousands of abortions are performed on adolescents. So the question was, is there really the need for a health exception? And what's interesting in Gonzalez versus Carhartt is, again, if you read the trial transcripts, not only in New York, but in Nebraska and in California, not a single physician could testify from memory of a case in which they had a woman whose health required them to perform this procedure. They speculated that they might have such a woman, and some of them now actually perform this procedure and taught this procedure, but not a single one of them could recall a single instance where the woman's health required it. And so it's in part on that empirical, factual basis that the court said that you simply cannot strike down a law as unconstitutional that allows a physician to begin the birthing process, on occasion situate the fetus in such a way that when the fetus is in fact delivered all but for the head, you can take a sharp instrument and drain the cranial contents from that fetus in order to make sure that the abortion is successful. Because, of course, the ultimate complication for an abortion is a live birth. We know that from the New York case where a woman was born after she had been subject to one of these D&E abortions, dismemberment abortions without arms. So the DNX procedure ensures that doesn't occur. But do we really want to live in a society where that sort of procedure is permissible, when we don't even have physicians who can testify that it's necessary to be available for the woman's health from their own experience? In addition to that, in that particular case, it was interesting when the experts for the plaintiffs were cross-examined, they recognized that because in order to do a DNX or partial birth abortion, you have to dilate the cervix more extensively than you do for a D&E dismemberment abortion, because you're only taking pieces of the fetus out in that case, that there was in fact a possibility of subsequent pregnancies being compromised by cervical incompetence. And so the question is it really safer for women? In fact, in this instance, Ms. G specifically talked about the increase in preterm births, which of course is the consequence of cervical incompetence. So is there room for compromise? Probably not. Is there room for consensus? Absolutely. Women should not be forced to obtain abortions in order to acquire or to attain professional status. Women should not be forced to obtain abortions because the men who are equally responsible for the conception of that child are abandoning them. And finally, when a procedure has not been established as safer, and when none of the physicians who testify in favor of it can identify a single circumstance of it, legislation should not be struck down because of the absence of a health exception. Thank you.
Okay. Does any of you want to respond to anything you've heard before I try to structure a conversation? I saw all of you taking notes, so if anyone wants to jump in, I don't want to get in your way.
I actually want to, there are many factual inaccuracies in the description of the record in Carhartt 1 and in Carhartt 2 that Teresa just went through, but I don't think it is, worth the time and energy to be talking about those here. When I mentioned the Canadian statistics, 2% of abortions after 16 weeks, we should be talking about the fundamental issues around how central it is to women's life and health to be able to make those decisions for herself, not jumping down the rabbit hole of the, straighten out the factual record. I mean, there's no question the leading obstetricians and gynecologists association, the trial records in all three cases, the affirmances on appeal were quite clear that intact D&Es are safer for some women. So I don't want to go tail to tail. I don't think it's worth our time. I think we should talk about the broader and more fundamental issues around women's right to access abortion.
Yeah, a question I would have is that if in fact there is a sense that later term abortions just shouldn't happen, or we should begin banning this procedure or that procedure, I would hope that then opponents of those later term procedures would really help get the word out about emergency contraception, that helps prevent a pregnancy, or the hope that women who face this decision would maybe get abortions earlier in the pregnancy, so we don't have women seeking abortions later in pregnancy. Unfortunately, some of the public policy that gets enacted pushes women further into the pregnancy, like the mandatory delay types of issues, like shutting down abortion clinics. So it's a tough one. And I think in terms of a sort of a different kind of rhetorical question is if we would make abortion illegal in this country, and I think Nancy talked about it in other parts of the world, what should the punishment be for a woman that seeks or obtains an illegal abortion?
Well,
and that's a question that doesn't usually get addressed.
let me respond to first the international claim that, in fact, the availability of abortion has made it safer. The country that consistently is in the top 5 countries for maternal safety is, in fact, Ireland, where abortion is illegal. So the availability of abortion is not what makes pregnancy safe. What makes pregnancy safe is the availability of antibiotics, the availability of an attendant during the birthing process. So if you have an obstructed delivery, there is someone that can assist you with that. The necessity of sterile environments for the delivery of babies. It is not, in fact, the availability of abortion, and the United Nations is in turmoil about whether they should ensure the availability of abortion or the availability of birthing attendants in order to ensure that women who want to continue their pregnancy can do so safely. Giving women simply the offer to terminate their pregnancies without making the delivery option safer is hardly a women-friendly solution to this. If we criminalize abortion, which I'm not sure we should, frankly, at least for the woman's part, I am confident that we should for the part of the physicians. Why do I think we should not criminalize it on the part of women? Because absent those sort of rare circumstances which we find in some of the earlier reported cases where women deliberately sought abortions and produced fetal material in order to obtain insurance proceeds. There's a reported state opinion where a woman was in fact sentenced to prison because it was established that the abortion was sought in part in order for insurance fraud, which sounds bizarre, and I think we're not going to find many instances of that, thanks be to God. Absent that, I do think that women's seeking abortion, at least in a significant number of cases, involves their despair of being able to go forward. However, that doesn't mean it's safer for them, and it doesn't mean it's the right choice. There are many times when I despaired of going forward in other circumstances where, because of the situation, you can't help but go forward, and you find that in the end it's a good thing. We find studies, at least out of Europe, it's difficult to get published in American journals, medical journals now, that indicate that where women were denied abortions, they actually were reconciled to the birth of that child and subsequently were happy with the birth of that child. Whether such studies have been performed here, we certainly don't find them published in American journals. So criminalization of women, that's debatable. Tort liability, absolutely. Criminalization of health providers, I'm in favor of.
I actually think that if we're going to punish doctors for performing abortions, we really should punish women for having abortions. Briefly, 2 things. One is the opening narrative that the professor gave about being a lawyer who has an oops baby. That's an interesting narrative. There are other narratives that might have a different message. Her message was that culture can demand abortion, and that's a non-liberating fact. I agree, culture can demand abortion. What's also true is that culture can demand maternalism. I might tell the equally poignant story of my 12-year-old cousin who called me in 1996 when I was involved with Planned Parenthood to tell me she was pregnant. And yes, I did say 12-year-old. 12-year-old living in a trailer. This is not a fantasy, it's a real story. 12-year-old living in a trailer in rural Georgia, and she's pregnant, and her father, who doesn't support her in any event, has found out she's pregnant and doesn't want her to have an abortion but wants her to have the baby because it's morally right. what should she do? Is this culture demanding abortion or culture demanding maternalism? Second thing is, I was struck by the human rights account. And it's interesting because in some of the earlier abortion decisions, the dissenting justices argued that abortion rights are not implicit in the concept of ordered liberty, nor are they part of our nation's history and traditions. And to argue that they're not implicit in the concept of ordered liberty, they would point to other countries. Well, in Europe, they prohibit and criminalize certain abortions, so therefore, clearly, one can have a just, free society, Western democracy, where abortion rights are curtailed. But this is a nice point. Now it turns out that internationally, the tides are turning. Europe has liberalized its abortion laws. South America is coming on board. And now it's starting to look like, you know, maybe actually abortion rights are implicit in the concept of ordered liberty. And maybe that's a good reason for us to stem the tide against the erosion of Roe and to get the frog out of the pot.
Right, I think it's at least clear to me that the name for this session, the search for common ground and compromise and consensus, was, in addition to maybe being a little bit overly optimistic, you know, a little imprecise, because we really are talking about compromise is different from consensus and common ground. And even when we talk about compromise, I'm hearing people talk about legal compromise on the one hand, or political compromise on the other. There's a lot of different things that we're talking about. And I wonder, I don't want to take too court-centered a focus today, because I think that's one of the things we should talk about, whether we need to stop thinking as much about courts and start thinking more about legislatures, political, public support for both positions. But I do think to some extent what's going on in the courts kind of sets the boundaries, if you will, for where compromise might be necessary, where we might search for common ground. So I just want to follow up on one thing that came up at lunch today when we were talking about the Roberts Court with the journalists. And it was Stuart Taylor who said he would be really surprised, I think he bet a hot fudge sundae, that he would be very, very surprised if Chief Justice Roberts or the Roberts Court were to overrule Roe, or he said sort of cut back on Roe in any broad or significant way, that would be a surprise to him. What do you all think? Do you agree with that? Would you be surprised?
I'm going to say something really flippant, which is that the boys on our side have been saying that for a long time, and I think they're just wrong. I mean, it's the same kind of Jeffrey Rosen, what would be so bad about reversing Roe would be the greatest thing.
I guess I would disagree when you, in both characterizations, surprise, surprise, in that the Raich opinion dealing with medical marijuana out of California, there were at that time 17 states where medical marijuana was allowed. But the court was quite clear that the legislature gets to decide what's legal and illegal. The medical profession doesn't. And if we're dealing with a federal law, the states don't. So the idea that doctors get to dictate legislation is inconsistent with the court's opinion in other areas. By the same token, again, we have some fundamental disagreements about the record in the Gonzalez case because we see there a debate in the medical profession, but we don't see either from the ACOG report, the American College of Obstetricians and Gynecologists, nor from the American Medical Association report, any specific instances where they can cite necessity for health purposes for the DNX or the partial birth abortion. So the fact that doctors can hypothesize that it might be possible in some instance that this would be superior simply does not warrant overturning any law as being unconstitutional. And they weren't willing to do it with the marijuana case, and it seems to me consistent that they wouldn't do it with PVA. On the other hand, I agree with Jeff Rosen. It would be a wonderful thing, obviously, if the Roberts Court were to overturn Roe. Sadly, I disagree that it's at all likely. I think that this court is going to be very incremental in its approach, very careful in its approach, and frankly, I'm not confident we'll see Roe overturned until we have a pro-life woman justice on the court, which hell will probably freeze over before we see.
I think that the current court could very well strike down Roe using Alito-like narrow proceduralist grounds, using some version of stare decisis, which looks to all the little cuts and slices that have already been made and says, "Oh my God, we've already done it." So I don't have any reason to think that it couldn't happen. On the other hand, I must say that that's a recent belief I've had in the last 6 months. My longer-standing view has always been that Roe would not be overturned because every sensible adult person understands that a woman needs to have at her disposal the option of terminating a pregnancy for the sake of her family and her health, and that what we're going to get is thousands and thousands and thousands of Missouri-like cutbacks, deprivations, disadvantages, but we'll never see complete end to the right. So I don't know. I mean, I guess flippantly I would say it could happen, but I think my longer-standing belief is that it won't happen because it's just too important.
Could I just interject here? The idea that anyone who holds a contrary opinion is unreasonable and unthinking is, to me, a throwback to where we were 20 years ago. That, in fact, my experience working with Jack Balkin at Yale, and when I presented on this issue at Harvard and NYU, Sylvia Law, was that, in fact, most people recognize that the disagreement in this case is not because one side is unreasonable. It is a disagreement over what facts we believe to be paramount in making this deeply important moral decision about the nature of our country.
So I come out of a public health background, and one of the reasons why I continue to believe abortion must remain safe and legal is from a public health perspective. And I think Nancy again referenced what happens when abortion is not available or is not legal, and a really horrifying case study of a very, very specific time period is Romania, where when Ceausescu was elected, he immediately enacted pro-natalist, anti-abortion policies, and it's like, if you look at the graph, it's like a top hat. They're coming up, maternal mortality is chugging along at its rate, albeit probably already too high. And when abortion is made illegal in almost all cases, maternal mortality shoots up, remains high for the entire period of his regime, and as soon as he is executed and the executive order is reversed, maternal mortality drops. So from a purely public health point of view, we know, whether or not we like it, whether or not we like to admit it, that women in desperate situations will find a way to terminate a pregnancy. And if it's not safe and legal and available, they will find an unsafe, illegal means to do it. We're already seeing, given that access is not readily available to most women in most parts of this country, women looking to who knows what on the internet as medications that perhaps might terminate a pregnancy. And I would venture to guess that what we will see as access becomes harder and harder, women turning up at emergency rooms with incomplete abortions.
But Allison, how do you distinguish? I mean, Ireland, at least culturally and medically, is much more similar to our country than Romania, and it has one of the highest women's health related to maternity. So it strikes me that we can all cite, we can cite Zimbabwe, we can cite Sudan, et cetera, but those really aren't similar or comparable medical
Although we live in a country that has an amazing medical advanced medical complex, and I live in St. Louis, which has boatloads of advanced medical treatments available, et cetera, and yet, just looking in Missouri, we have horrible maternal child health statistics. Infant mortality is still outrageously high, low birth weight, preterm deliveries.
But those are women who chose to continue their pregnancies, the vast majority.
That's right.
So the availability of abortion won't change that.
Right, but when you're saying that even in Ireland where it's illegal, there's good
maternal
health, if abortion's legal here and we have shitty maternal health.
I think we're in agreement.
Maybe.
The question is the cause.
Okay. So let's assume for a minute, Allison, that Allison is right, that we are perhaps now living in a post-Roe world, or that if not now, then maybe sometime soon we will be, and think a little bit about what that means and what it means for advocates on both sides of this issue. I mean, people have said before that it's time for advocates of abortion rights to take this less court-centered approach, think more about political strategies and building public and political support for reproductive rights and the entire package of reproductive rights, Nancy, not just abortion rights. And I think we've talked around a little bit what that might look like, whether it means thinking more in terms of public health, human rights, things like that. But what do you, and I guess I'm speaking to the three of you first, what do you see as the sort of the best available strategies if we're thrown back entirely into the political realm?
I live in Pennsylvania. We've had a couple of significant decisions coming out of that state, Planned Parenthood versus Casey and Thornburg versus American College. It's not clear what kind of abortion rights we'd have in Pennsylvania, but what is clear is that in Philadelphia, near where I live, there are thousands of children who are hungry. There are thousands more who go to schools that are violent, dilapidated, understaffed. There are people living in public housing and private housing that's inadequate. People have can't even afford to pay for heat in the wintertime. I would worry about the overall implications of lack of some ability to terminate pregnancy, control reproductive capacities in a radically post-Roe world. I just think that the implications for families, family welfare, education again, hunger, nutrition, it's overwhelming. I mean, we're in such bad shape in Philadelphia that this is the last thing we would need.
Yeah, and I just want to remind us that women from Ireland go to England for their abortions, just in case we forgot that. I think the thing that is frustrating to me working on the front lines in a state is the lack of willingness to really promote access to contraception. And as we've seen now again in Missouri, a willingness to protect our teens from information. So, by no longer allowing, and again, it's not just that Planned Parenthood has the education for all, but by seriously limiting who and what kinds of information can be imparted in schools. So what's most frustrating to me also, then, we have a governor who wants to protect pharmacists who refuse to dispense birth control. So until we can get to a place where our public policy makes access to prevention really a core, so that unintended pregnancies can be brought down, we're never going to be able to deal with the notion of a post-Roe world or not having legal, safe abortion available.
Well, when people talk about common ground in this area, you often hear that there can be common ground around preventing unwanted pregnancy through things like access to contraception and access to sort of real and effective sex education. I mean, it's your sense that politically speaking, that's just not true, or?
It's very difficult. It's very difficult, and just this last year, I mean, if you bring it down to an issue that's not as stem cell research, this was an issue that clearly divided the anti-abortion movement, to those that thought this was good for life-saving cures, to those that thought that this was, destruction of human life. And when you get it on that level, it's very hard then to look at, so where's consensus on access to contraception, access to emergency contraception, and then sex education that provides information about those services. And we've found it very difficult in the face of opposition in Missouri to find a consensus there.
Yeah, I just want to add a couple things on this sort of post-Roe point. One is that the Center did a report, and we're about to update it, called What If Roe Fell, that looks at the legal building blocks already in place if Roe were reversed. And you've got states that are now passing laws that would automatically recriminalize abortion if Roe is reversed. You, of course, have enjoined statutes on the books that could be lifted if Roe was reversed. You have policy statements in states you'd be surprised about, like Illinois, that their policy would be to protect life from the moment of conception. And so we looked at the various factors and thought about 30 states would be likely to recriminalize abortion within a year of a Roe reversal. And that's obviously serious, and people say, well, what's your strategy? And in some states, I mean, the reason the courts are important is in some states like Mississippi, in which there's only one clinic now, but in which there's no legislator in the Mississippi legislature who is pro-choice or who will verbalize that, there isn't a political strategy. That being said, the second point I want to make is that the pro-choice movement has not just relied on a court strategy. I mean, I happen to work in an organization that is very court-focused. That's what we do. But Planned Parenthood and NARAL and other groups have spent years on sometimes very successful political strategy and have even in states won elections on the pro-choice issue. And it's another one of these, you know, it's not like an urban myth, but it's like just a bizarre myth that the pro-choice movement has not been using politics and electoral strategies as well as the courts. And then my last point, before I just, you know, absolutely, you know, scream, is that part of the problem with the whole, you know, conception of compromise or the why do you even rely on the courts at all is that it continues to ignore the fact that the differences here are fundamentally different ideological perspectives. And it was talked about a little bit in the Backlash panel yesterday about the fact that there is, on the issue of Roe, the opposition has a worldview that would include a religious state in the United States and that believes there is an answer to moral questions about questions about sexuality, the role of women. And so on things that you'd think there'd be compromise, like why aren't we really, really pushing contraceptive access, you know, for all women, why can't we have comprehensive sexuality education? It's because the views are not that there should be comprehensive sexuality education, but there should be teaching abstinence only, and that the only acceptable form of sex is between a man and a woman within marriage. That is a different worldview that says that's the only acceptable form of sex. And so there isn't you can't compromise. And on this point, I always have to quote Barry Goldwater, who in 1981, we're talking a long time ago, was just outraged at what he saw as the capture of the conservative agenda, which he felt that he was a true conservative, by the religious right. And he said, you know, throughout our 200-plus years, public policy debate has focused on political and economic issues on which they can be compromised. So his point was trade policy, immigration policy, economic issues. You can compromise on those. But he said there is no position on which people are so immovable as their religious beliefs. And at heart, this is what the battle is about, fundamentally different views and people's religious beliefs. And that's why the court is an important role, because we do have separation of church and state, and they are there to respect both sides, as the court have said. Yes, people of good faith have fundamentally different views on this, but they are there to protect those that have a fundamental view that would allow women to make these decisions, that would not necessarily have traditional stereotypical roles for women, and that would not think that sex within marriage between a man and a woman is the only acceptable form of human sexuality.
Am I allowed to respond since you asked only the three that?
No, then I was going to ask you a
Okay.
separate question, which is,
Well, let me respond
Yeah.
if you don't mind. Because I think that on both sides there are calculations if Roe fell. And the study I have seen says 17 states. For example, we have a Fifth Circuit opinion that said that even those states who retained their criminal prohibitions of abortion, sometimes through great political effort, where others wanted to repeal them, those statutes are no longer good because they subsequently passed statutes related to parental consent, or they passed waiting acts, et cetera. And so in the Fifth Circuit, which includes Louisiana, by the way, they said that one of the most pro-life states in the Union, they've said that any existing criminal prohibitions on the books are no longer good. Now, they might revisit it depending on how Roe was reversed, but that doesn't give me any comfort that even in those states outside the Fifth Circuit where we have managed to maintain it as a law on the books, even though it's unenforceable, that we will be able to retain it after Roe. the projections I've seen are not 30 states of criminalization. I have seen 17. I think that comes from stateline.org, which is the State Conference of Legislators, which is neither pro-life nor pro-choice. So I think that we will see movement there. I've also seen, though, that that same report indicated that there will be a number of states, some of which already have, state constitutional protection of the right of abortion. So what it will do is return the question to individuals who can act as citizens to express their most deeply held belief, whether they are religious in the sense of believing in a God or religious in the sense of believing that secularism should be God. Either way, that we can begin to have those sorts of debates.
By returning it to the...
Yeah, one question, I guess, or idea I would float is that last time I spoke at a Federalist Society panel on reproductive rights in the Roberts Court, it became clear that many of them thought that the overruling of Roe and returning the question to the political branches would also be a compromise, a very deep compromise for many of the people who were in that room, because they believed that the right answer under the Constitution was that fetuses have equal protection rights or privileges and immunities under the 14th Amendment, and therefore it's sort of unconstitutional to permit abortion, so that returning it to the political branches would itself be a very difficult compromise for many of them to make. And I just wonder whether any of you have any reaction to that, or think that that's a view that might at some point sort of percolate up through the law more than it has now.
It's very commonly heard, I think, in academic circles these days. Lots of young scholars are experimenting with the idea that fetuses are constitutional persons, and that the real basis for overturning Roe should be the recognition of the constitutional status of the unborn. And I think it's a very interesting and difficult point to make and to defend. I think it's worth talking about whether we should see the world that way, but I think that ultimately the question is not a sort of a neutral one, let's look at the book and see what it says kind of question, but rather it also is the time for deep moral reflection about how we think we ought to understand the balance of rights and interests and needs in our society. And if we could ascribe constitutional rights to the unborn if we want to, and we could read the text that way, and we could find some humanity in our heart that says we ought to be that expansive. But I think not doing that doesn't mean we're moral monsters, and in fact it would be a way of recognizing the human rights interests that women have in being the ones to decide. Larry Tribe, long time ago, made, I think, a very good argument when it comes to the question of turning it back to the states. I mean, it's his point was that, why should a woman's entitlements and her rights and her powers and her capacities and her opportunities depend upon what state she happens to live in? I mean, why should the fact that one woman lives in Missouri or South Dakota or Pennsylvania have a bearing on whether or not she has to have 4 children or 1? It almost begs the question about what we think women's human rights are to say we ought to turn it back to the states, because in a way that's a way of saying we don't think it's a human right. We don't think it's all that crucial. We think it's not like, say, the right to be treated equally as a black person or as a Jew, but rather it's something different, like the right to get ice cream on Sundays. And so let the people decide. I just think it's too important to and I think that you made the very good case. It's too important. It's a right of human rights dimensions, and that's why it shouldn't go back to the states.
But it's not in the text of the Constitution, unlike the equal protection of people by race. And so where we have a question that has not been determined, and as you well recall, we didn't have the protection of African Americans in our Constitution until there was a very bloody war, and it took the enactment of an amendment to that. It didn't take simply a judicial opinion to do that. And so the question is, where there is an undecided issue, do we allow 9 individuals who could go either way? I personally am not optimistic that they'll go my way, but could go either way, and in grafting language on the Constitution? Or do we trust the people to exercise their political judgment as we did when we crafted the Constitution? I think that's a very important question. I do think, though, that the question of whether, if they reverse Roe, will they reverse it on the fact that there is no constitutional text and therefore no mandate for the court to strike down laws as unconstitutional and leave it as a political question, as opposed to the human life issue, is one that, frankly, people who support the right to abortion are far more afraid of than those on our side are optimistic about. A journal that I suspect very few people in this room read regularly is First Things. You can find it at firstthings.com, and there you will see a debate between Judge Bork, that great ACS member, Judge Bork and another scholar, where Judge Bork says it would be unreasonable to reverse it on the humanity of the unborn. And so even within the pro-life movement, there's a huge debate about whether we would destroy the political structure of this country by essentially doing to people who disagree with us what's been done to us for 30 years.
Do we have time for questions now? Great. Microphones in back.
Hi, my name is Amanda Kissel. I'm from Pace Law School. This is actually a question for Teresa. I was wondering how you can reconcile the fact that you were so outraged at the idea of being denied a choice as to whether to carry your child to term while being a partner in a law firm, with your point of view that other women should not have the choice to be able to terminate.
Oh, I think we interpreted my experience differently. What I was outraged about is that as a condition of a woman in the professional world, that I could not engage in what is a very natural circumstance, which is finding yourself pregnant if you engage in sexual intercourse. And as a married woman, I do, and I did. And so why would society structure itself in such a way that I could not continue that natural circumstance? That's very different than saying that women who choose to voluntarily engage in sexual intercourse should have the right to destroy that which is within them, which debatably is a human person, because they don't like those consequences.
Wanted to piggyback on that last question a little bit. I was going to ask you a similar question that had to do with that anecdote. And it seems to me that it rests a little bit on the assumption that being able to be fully a woman in the workplace or in our world is synonymous with being a mother. And I just wonder if that, and you just said now that that's a very natural thing, but what about women who want to be women and believe that they are feminine people, that they are women, but do not want to be a mother at that time, and want to engage in sexual activity and consider themselves sexual women, but do not want to be mothers?
I think that, first off, and this probably is a point of debate at this particular conference, whether sexual identity is a matter of what I want rather than biological. I think I'm a woman because I'm a woman. I was born with certain equipment and certain hormones, and that's the way it works. I recognize there are those in the academy that dispute that and believe there are 5 genders. I think they're wrong, but that's for another panel. So the fact is that if you're a woman under these circumstances, you have to make the decision of what consequences you're willing to accept by virtue of sexual activity, in the same way that I have to make decisions about what consequences I'm willing to accept about intellectual activity. If at the law firm I had decided that I was interested in pursuing a graduate degree in art history, I would not expect the firm to accommodate that. And yet we demand that firms by law accommodate pregnancy. Why are some choices superior to others? I think the fundamental interest is because procreation, the creation of new life, is far more important than my fulfillment as an art historian.
have a comment and a question for Professor Collette. I was struck by your wavering over whether women should be criminalized for undergoing an abortion procedure when you seem to have no hesitation regarding the criminalization of doctors who perform it. It seems to me that since women will make up 100% of all the patients, and men, at least now in 2007, there are more male doctors than female doctors, it seems to me you're perpetuating the very stereotype that you claim to hate. I'm not done yet.
I'm sorry.
In that you talked about the woman's fragility and her despair at getting this abortion and the distress it presumably causes her. It seems to me you're doing an expert job of perpetuating that stereotype of women as somehow being less of a strong species than men are. My question for you, piggybacking on the comment, is this whole question of criminalization. We know that you want to criminalize the doctors who perform it. We know you're at least thinking about criminalizing the women who get it. We know you'd like to criminalize adults who transport minors across state lines to get abortions. So that got me to thinking as to who else are we going to criminalize. And I jotted down a couple of options for you. Maybe the teachers who teach sex ed, or who dare to talk about more than abstinence in a health class. I thought about the security guards who work at Planned Parenthood clinics and make sure that the patients can get in and out of the clinic safely. Thought about CEOs of insurance companies who decide to put things like contraception, have that covered on their plans. Thought about the head of the FDA who decided that EC could be over the counter for women over 18. And I thought about me, who works for NARAL Pro-Choice America and is very proud of that. So I'm wondering, who else would you like to make a criminal in this society?
May I respond to your initial premise?
Please do.
The simple fact is that our experience with the drug laws is that the people who go to prison are the poor, predominantly black women who act as carriers for the dealers. I'm not a big fan of that. I think that's a real problem. If the people who actually are in a prominent situation of directing the activity are the ones that escape professional and criminal sanction, but the people who seek it out because of individual suffering and low income and other characteristics are the ones that bear the burden. So I would take that lesson, and I would look at the fact that at least I'm surprised NARAL Pro-Choice America doesn't think that women grieve this decision on occasion and in fact find it to be a difficult decision. I disagree with you. When we look at the National Abortion Federation textbook on abortion, they in fact say that women do often experience regret about this, experience regret of its necessity at the outset, and experience regret after the fact. So I think that the availability of things commercially is quite different than the consumer who feels driven to it.
And who else are we going to make criminals?
Well, it depends on what legislation's before us.
What would you like to have?
I have not sat down and thought about it.
Seems to me you've thought about it a great deal.
I think she wants the mic, but I could be wrong.
I wanted to go back to something that Professor Alan Castillo said at the very beginning, referring to Justice Kennedy's opinion. In my lifetime, of course, Roe has always been in existence, and I've heard a lot of debates, many very intelligent about the constitutionality of abortion and various legal reasons, but when I read his opinion, it was the first time that I had heard anyone in a position of authority put forward the idea that women were not capable of making this choice. And I was very emotionally upset when I read it, and I felt personally insulted by the opinion, particularly considering that a person of that stature would put forward that kind of opinion. You mentioned that it was a mistake, and I wanted to ask you what kind of effects you thought this would have in other areas. It seemed such an archaic idea to me, and such a ridiculous one, considering that people regret many serious decisions. People often regret getting married, but we don't get rid of the institution. and how, if it is a mistake, how progressives should respond, and what you see, where is this idea coming from, and where you see it ultimately going.
Yeah, thanks. I want to be clear that it isn't because I don't agree with the opinion that I don't like it. I think that the dissenting opinion in the Thornburg case, which was a brilliant anti-abortion argument by the Supreme Court. I include the opinion in all of my courses on constitutional privacy rights, because I think that that opinion, that dissent, nicely laid out the anti-abortion rights arguments. But I found that the opinion that you're just describing, you're referring to, was troubling both because of its paternalistic attitudes towards women, oddly turning us into women incapable, people incapable of dealing with the emotional consequences and medical details of our care, when, as I earlier recited, there are so many ways in which women make hard choices all the time and face incredibly difficult, gory decisions involving life and death. So the question is, what makes abortion special? Why? What's the basis of abortion exceptionalism? Why, in this context, we ought to care about women's having to make hard choices on their own and having to deal with bloody and gory and emotionally wrenching things on their own? Why this thing? And I think the answer is because ultimately we're not really concerned about the women. We're really concerned about the fact that we think that the unborn are constitutional and or moral persons, and that it is so horrible to destroy their lives that we ascribe to women universally or virtually universally an added degree of pain in order to account for our sense that what they're doing is really, 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 really quite bad. So it's exceptional. It's exceptionalism. It's paternalistic, I think, and ultimately, though, it's about the unborn. And before I was a law professor, I was a philosophy professor, and I have spent many years studying the arguments about whether or not the unborn are persons, human beings, and so forth. And I think that those are interesting, things to think and worry about, and they're important. I've made up my mind. You might have made up your mind. And the thing that I thought was so great about Roe was that it gave everybody the ability to make up their own minds and to do what they think is right. And without Roe, we're having some people's morals trump others.
And also just to add that it has been, and we're hearing it today, we're hearing two things today that are part of the strategy of the anti-choice movement. One is the abortion hurts women's theme. And I think what was very disturbing to us was to read Justice Kennedy's decision, and all of a sudden became this non sequitur conversation about, although there's no scientific proof of this, I think we can all assume that women come to regret their decisions. And knowing that this has been a strategy of the anti-choice movement, it was very disturbing to see, as I call it, the non sequitur riff in the middle of Justice Kennedy's decision, which was not there when he wrote his vehement dissent in Carhartt 1 6 years ago. And the point here isn't, again, as your question makes clear, people regret all kinds of decisions. And yes, some women regret their decisions to have abortions, and some women regret their decisions to bring their children to term. Some women regret being mothers. They even tell their children that. We all have friends, right, whose mothers said, I wish I'd never had kids. It ruined my life. There are a host, marriage, divorce, everything. That people have different decisions on. But anyways, but that is what's so troubling. And another kind of political strategy is to say, oh, we're not going to criminalize women. I mean, it used to be the theme was abortion is murder, and that was consistent with the very deeply held belief that it's true. And the consequence of that would be both the women and the doctor following that ideological and religious position should be prosecuted. This is a way to sort of take the reality of what it means to criminalize abortion out of it. And the question is true, even if you didn't, if women were excluded, who else would be an accessory? I used to be a federal prosecutor. What about the sister that gives the money to the doctor? All kinds of other people can be swept up in conspiracy law. So I think that it is, that is what is so kind of disturbing about the court's decision, and why we have to be very sharp on looking at this theme that we're hearing. I would just recommend everybody reread Stephen's opinion in Planned Parenthood versus Casey, because on this issue around, does abortion hurt women? Do they regret their decisions? The decision-making, interfering in the decision-making 24 hours, the scripts and so forth. I mean, Stephen, echoing Brendan before, gets it so well. I mean, he basically says in that decision, stay out of women's headspace, is the way I like to characterize it. Stay out of women's headspace. And that's because he says, women have the right to equal dignity in their decision-making. And again, this is a theme that resonates in the human rights perspective to this issue. And he says, the mandatory 24-hour delay appears to rest on an outmoded and unacceptable assumptions about the decision-making capacities of women. And then he goes on to say that part of the constitutional liberty to choose is the equal dignity to which each of us is entitled. A woman who decides to terminate her pregnancy is entitled to the same respect as a woman who decides to carry the fetus to term. So that is what should be the robust constitutional analysis, is Stephen's concurrence in Casey.
It's interesting that this objection is raised commonly, but you don't hear it when you're trying to pass legislation, which exists in many states, that requires waiting periods for mastectomies, for hysterectomies, because there were documented abuses of it. And so to the extent that we think that there are particular practices that are engaged in that are unique or unusual in their medical setting, there are very few surgical procedures where you go in, and the day you go in and you meet the physician, if you meet the physician, which is rare throughout the country until you're up in the straddle, but nonetheless, where you go in and they say, oh yes, you need surgery, we're going to do it today. Can you think of any other surgery? We just did a consult with our 17-year-old daughter yesterday for having her wisdom teeth out, and they wouldn't do it the same day, even though she's leaving for college soon, which we would very much have liked them to do. So the unique treatment of this perhaps may be the unique nature of where it occurs and the way people engage in the practice, just as there are laws that exist that require women who are seeking mastectomies or hysterectomies to be afforded certain protections.
I'm afraid we're out of time. I need to announce just that at 6 o'clock this evening there'll be a reception just outside the Marriott Ballroom, and at 7 o'clock the banquet begins in salons 2 and 3 of the Marriott Ballroom with remarks by U.S. Representative Conyers. And I hope you'll join me in thanking our panelists.